Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about recent decision that have been given by the Madhya Pradesh High Court with regards to the anti-conversion law that the Madhya Pradesh government and legislature has come up with in last few years. So in this particular video, we are also going to discuss in details about what are the salient features and provisions of MP Freedom of Religion Act, as it is called, and what has been the verdict of High Court in this particular regard, and what are the problems and challenges in the implementation of this particular law. So first of all, to give you the brief context of our topic, so in a decision that has provided relief to the interfaith couples who are trying or who want to marry, MP High Court have restrained the state government from prosecuting any adult citizens if they solemnize marriage on their own volition. That means if two adult person without taking care of any religion, without worrying about religion, if they want to marry by themselves, by their own decision, then the state government cannot go and prosecute them, even if there has been some issues of religious conversion. So this is the main underline as far as the decision of the High Court is concerned. Such actions, basically, if we talk about as per MP Freedom of Religion Act, such actions were deemed to violate Section 10 of this particular act, and that is why government could go and prosecute it. And in this regard, the Advocate General of Madhya Pradesh, Prashant Singh, has said that against this decision of High Court, the state government will challenge it, and in shortly they will go to the Supreme Court and to ensure that the MP Freedom of Religion Act and Section 10 is upheld in the Supreme Court. So if we try to understand the background of the act, what we can see that somewhere in the year 2020, the Kamal Nath government, that was Congress government, that was toppled, and in place of that, the government of Bharatiya Janata Party led by Shivraj Singh Chauhan came into power. And when he came into power, the government announced that the intention of the government is to curb religious conversion that is being carried out solely for the purpose of marriage. And it is in this regard the government then decided that they will pass another act that is called as Madhya Pradesh Dharm Swatantra Adhiniyam Act 2020. This act basically has replaced the same act having similar name that was passed in the year 1968. So 1968 Act actually also has faced a challenge in the High Court of Madhya Pradesh. However, in the year 1977, when the matter was referred to the Supreme Court, that act was also upheld. The beginning of the promulgation of the act did not directly begin with the passage in legislature. First of all, an ordinance was promulgated, and once this ordinance was promulgated in the next year, that is in year 2022, 2021, finally the matter was referred to the Legislative Assembly, where the act was passed with a voice vote, and also there was chant of Jai Sri Ram and all these kind of things. Then MP, after the passage of this act, became the third BJP ruled state that have a separate law for dealing with the cases of conversion, religious conversion, after Himachal Pradesh and Uttar Pradesh. So now let us try to understand what is Madhya Pradesh Freedom of Religion Act, or MPFRA 2021. So first of all, the intention of this act is that to prohibit any use of misrepresentation, force, undue influence, coercion, or any other fraudulent means including allurement such as promise of marriage to facilitate conversion, religious conversion, especially of Hindu community into some other communities, as into some other religions such as Muslim religion and Islam and Christianity, such as Islam and Christianity. Second, the act clearly states that any person who is found to be violator of this particular act can get 1 year to 5 year in imprisonment, especially if the conversion that has been carried out has been done of children, women, or people belonging from scheduled caste or scheduled tribe. In that case, a violator can even get prison terms of between 2 years to 10 years. Along with that, they'll also have to deposit a fine of rupees 50,000. And if the conversion is being done on a mass scale, especially that is true with reference to the we can say missionaries activity that is going on in different parts of India. So keeping that in mind, the state government clearly said that if the mass conversion is being done by any individual or group of individuals, they can face 5 to 10 years in prison, and at the same time they'll also have to deposit a penalty of rupees 1 lakh. Not only that, they has made this, under this act, the act of religious conversion and the crime of religious conversion has been made cognizable and non-bailable. Cognizable means that the police officer do not need to have a warrant to arrest the person who is violative of this particular act. As far as the complaint with regard to this particular provision is concerned, the victim's parent or the victim's siblings, as well as anyone else, including a guardian, they can actually complain to the local police station if conversion has been done, and with the permission from the local court, they can also go. Similarly, as far as the investigation of the crime under this particular act is concerned, this act mentions that a police officer must be the rank of sub-inspector and above to investigate the crime that has been committed under the purview of this particular act. However, there has been some provisions which has made conversion valid, and in that context they have said, which is the section 10 of MPFRA, that if any individual want to undergo the process of religious conversion, then the individual as well as the priest who is facilitating the conversion will have to submit a declaration of the intent to convert to the local district magistrate before 60 days from the date of conversion. If someone is not able to notify to the district magistrate, so such failures will render the wedding null and void. For example, if the wedding between two different people coming from two different communities has occurred and they have not notified this to district magistrate, then the wedding will be considered null and void if the religious conversion has taken place. Not only that, the duty of priest has been quite significant, has been considered quite significant here. And if even the priest is not, priest has failed to notify about such kind of process, then priest can face 3 to 5 years in the prison with a minimum fine of rupees 50,000. So it is in this context the High Court of Madhya Pradesh has given their judgment, and the judgment has been clearly said that as far as the section 10 of MPFRA, which is about the what we can say the necessity to submit the declaration of intent to convert, there HC has clearly said that prima facie seems unconstitutional in nature, and respondents shall not prosecute the adult citizens if they solemnize marriage on their own volition. If there is no pressure, if there is no undue influence, if two adults are coming together on their own volition, by their own will to have marriage, then such citizens should not be prosecuted. And that is why under section 10 of the Act of 2021, this MPFRA Act, no coercive action for violation will be will be done. Now, this is not the first time the High Court has taken a decision on this particular instance. Similar law exists in the state of Gujarat as well, and Gujarat High Court also has given verdict in the same regard. Gujarat High Court has clearly said that several provisions of the similar act, that is known by the name of Gujarat Freedom of Religion Amendment Act 2021, the Gujarat High Court has decided to stay the provisions because it says that some provisions, the similar provisions where there is a necessity to report to the district magistrate, or there is this all this we can understand there is a limit on the conversion. So these are something that interferes with the intricacies of marriage, including the right to the choice that any individual has in India as per the constitution, and thus in a wider sense this provision is infringement of article 21 of the constitution of India. So that has been the decision of the Gujarat High Court. So what is article 21? Let us try to understand that also in more detail. So as far as the article 21 is concerned, it is broadly categorized as a right to life, where it has been clearly mentioned that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. Now, the right of life and personal liberty has been taken in a very broad form by the Supreme Court and the High Courts in the various decisions that has been given after the Constitution came into existence. And life, especially if we talk about this particular terms, is very broad, and it is not merely the physical act of breathing or the physical act of existence. It does not basically mean that mere animal existence, but it has a much wider meaning, such as right to live with human dignity, right to livelihood, right to health, right to we can say pollution free air, and even right to travel outside, right to choose one's life partner, right to have right over one's decision to take decision to have what kind of food one want to eat. So all these come under the right to life, and that is why Gujarat High Court has said that such kind of laws or the provisions of such laws are in direct interference with the Article 21 of the Constitution. So that is all about this particular video. I hope you understood about the gist of what has been the decision of Madhya Pradesh High Court with regards to the anti-conversion law. I hope you understood the topic. If you like the video, please hit the like button, share it with your fellow aspirants, and subscribe our channel for more helpful content. Thank you very much.